This is the second paper that we've released around the reforms necessary for electronic conveyancing. And so today's session really is a brief presentation from me to give you an overview of the substance that's contained within the document, but primarily it's for your purpose to seek any clarification or any further detail that you may require. One, to further progress your knowledge on the reforms that we're proposing, but two, to allow you to be in a position to provide a submission that we can consider to feed into our draft bill for the reforms that are necessary. So really this is a brief presentation, but primarily if you have any questions as I move through the slides, I encourage you to ask, and either I will be able to answer them or some of my technical experts in the audience may need to assist if that's the case. So please, I encourage your participation. Where are we today? We've said numerous times that electronic conveyancing was coming to South Australia. It was in 2015, it was then in the last quarter of 2016. We've had confirmation from PEXA. It is now the second quarter 2016 where South Australia will be implemented with electronic conveyancing. PEXA have already been over 3 or 4 times in the last 2 weeks to start the IT work and the definition associated with the IT infrastructure and obviously the changes we need to make to Salus to integrate with PEXA. So there's a fair amount of activity happening in the IT space. Obviously to complement that, we need to introduce reforms around the policy, the legislation and the system. People will be aware that we decided to take a 2-stage approach to the necessary reforms. So earlier this year we had changes made to the Real Property Act, and those changes were primarily around introducing priority notices and the VOI regime. And so they've been in since the 27th of April. Welcome. Priority notices, warning. Priority notices were implemented with Salus on the 27th of April. It's fair to say they've been received lukewarm. We've had probably a couple of hundred that have been lodged since April, which to me is not quite the number I'm looking for. And so I'm really keen to increase the take-up and the use of priority notices. Through my travels, I've had a number of people pause and take time to speak to me, and their primary message was, we don't quite understand what the benefits are to us as practitioners when it comes to priority notices. We know they exist in Queensland, we know they exist in Tasmania, we know that their uptake's 90-something%, but that hasn't resonated with us. We don't see why do we need these things? What do they do? What do they afford us as people representing the landowner or our clients? And so there's 3 things. One, I've mentioned previously, it assists with removal of the dupe title. I've got a slide and it's part of the reform paper, but I'm really keen to remove or abolish the relevance of the dupe title. 2, it assists in dual lodgement platforms, i.e. paper and electronic. People be aware when you lodge through PEXA, it's automatically noted on the register book. When you lodge it through drop and go down at the LTO, we have 2 to 3 days backlog. So there's a disparate noting system that's in existence, and so there's a delay between those 2 systems for updating the register book. And the third point, which I may have failed, I think, when we were introducing and discussing priority notices, was about the fraud prevention mechanisms that it allows us to take, and especially you as practitioners representing your client. I put to you an example. We have a legitimate landowner, so I am Brenton Pike. You've VOI'd me and you've attached me to my property at Golden Grove. You've done everything you possibly can in that regard. But I decide to enter into 3 contracts with 3 purchases. We've got 2 lodgement systems, we've got an electronic and a paper. Settlements can happen within a 3-day window because of the disparities of the lodgement platforms. No one would have any idea that I've sold the same property potentially 3 times. So what we'll have in that situation is the purchasers will hand over their money, or the banks will lend money, or they'll hand over their own money. the 3 series of documents will be lodged with me. I'll go back to my legislation, and priority is king. So whoever is lodged first will probably be capable of registration and will be afforded protection under the system. The other 2 purchasers have no protection. They've handed their money over. The vendor's gone overseas. The only person they can have a claim against is you, their practitioner. And so this is the world we're moving into, and this is why I think the use of priority notices is critical to overcome those risks to you and your clients. You get, in the case that I've explained just then, if you get a contract on your desk and you lodge a priority notice, any further contracts you search the register book, you'll see there's a priority notice. You say, hey, we've got a problem. And there's an early alert to you and your client that something may not be as correct as it should be. And we're moving more and more into this domain.
In that scenario, if there's a paper title, how do you do 3 settlements?
If there's a paper title, we're moving with 2 things. Firstly, I would say the use of a paper title has been relied on too heavily in the past. It is what it is. I don't need to explain what it is. And 2, we're moving to a world where we're removing paper titles.
But at the moment, that scenario couldn't happen because
Yep.
you wouldn't collect a title at settlement because it already would have been handed over.
But in its very simplest form, the title's a green bit of paper. And we've had a number of occurrences. I won't overstate. It hasn't been huge, but we have had a number of occurrences where people have come in downstairs and said, "Oh, can you just check to make sure this is a valid duplicate title?" And there are circumstances that it is a photocopy. And so it doesn't happen, touch wood, very often. And we have been lucky that we've never had any third-party fraud in South Australia. But we're moving into a world where more things are happening online. They're being done at arm's length. There's checks and balances.
If they've been using priority notices in Queensland, and I have a friend who's a legal practitioner up there, they still have quite a few instances of fraud in property dealing. So how's it helped them when we don't have any here?
How's it helped them? I'd have to ask my colleagues in Queensland about that, because my understanding is they haven't had a tremendous amount of fraud. But I'm happy that
it's.
I agree. But that could be because our policies and procedures are more robust, and our industry, the way our industry work with those policies and procedures, has been well regarded in the past. So what I would say to you is, does that mean we're ahead of the game? And I believe priority notices continue to keep us at the forefront and to be ahead.
Oh, but why don't they work in Queensland?
I'd have to seek, I'm not sure, I'd have to seek the facts of that to explain.
Just coming back to your example, if there are 3 transactions, no duplicate titles anymore, there are the 3 transactions, and you've got 3 different practitioners who do lodge a will. So the priority notices are used. Coming back to the priority notice, as I understand it, has to be quite accurate. So if the circumstances, can change and beyond our control that render it, so we could lose, where I'm going, I could lose priority because my notice is not quite right, and then someone else has got a notice and we've still got a problem.
Yep. But what you would have in that case is you would have full awareness of what's going on, and you'd be diligent to ensure whether 1, you go ahead with the settlement, or 2, you take an action in the court. It's information you'd have at your disposal to be able to make an informed decision, where in the absence of priority notices, you have no information at all and you just go forward to settle, and then it would come up. So in that situation where there is a true competing priority issue, that's a bigger issue than just priority notices in the torrent system. That's probably a matter for the court to understand all the facts to determine who has a legitimate right. But the priority notice would alert you to that, and so therefore you could speak to the other and say, well, hang on, we've got a competing issue here. We're not going to settle, or we are going to settle, but you would have all the information for which you can make an informed decision. And one of the things I will say, and priority notice is, one of the other things that has limited its take-up has been the fact that practitioners primarily have been telling me, we don't know the mortgagee, or we're uncertain. We're uncertain about who the mortgagee may or may not be. We have an idea because some of the big FIs have brands, and so we know it might be Westpac, but there's a number of brands, etc. And so what I do have in the legislation and currently is the ability to where if there is an incorrect mortgagee, the practitioner or whoever can give me a letter to say, look, whilst it says in the priority notice the mortgagee is Westpac, it's actually St George. I'll be issuing a notice soon where we'll clarify that, where that will be acceptable to see if we can remove that sort of barrier and allow take-up to occur. What I will say though, the priority notice does need to clearly capture the makeup of the series. So it has to be, if it says discharge transfer mortgage, it must be a discharge transfer mortgage. If the mortgagee has changed through the journey of the priority notice coming on and your documents coming in, I think I'll accept the letter to overcome that barrier to take up, if you like. So that's, yes.
In what you were talking about before, your case with the 3 settlements,
Yep.
that could still be overridden by every title having a barcode and every lodgement having that barcode on that title scan, and
Yep.
then there would be instant recognition on the system
Yep.
that there was a settlement taking place, and that would alleviate any problem. You could still keep the paper title.
How do you deal with that in PEXA? We're moving to an electronic world. We've got a national system that's moving us to an online world. Whether it happens in 12 months or whether it happens in 5 years, it's here. What I would say to you is is a solution that they've gone down the path in New South Wales. It costs significant money, requires significant infrastructure. We are currently in our journey of, reforming the conveyancing system generally. I'm not sure we'd invest in that level of infrastructure. I think there's other things you could employ that offer the same safeguards. Priority notices. I look forward to you all lodging them.
So it's probably just going off a little bit, but
That's all right.
I believe that, this is heading, to electronic conveyancing, all well and good, but I believe that it starts with an agent selling a property generally. Now, a lot of agents,
It is.
some of them, like I had an instance where they held the contract for a month because something wasn't, a special condition hadn't been
Wasn't fulfilled.
fulfilled. So my client didn't inform me. I had no idea until I had a call from the bank saying, where's the transfer description? Now, so in that instance, how can we lodge a priority when settlement's a week away? Do you know what I mean?
Yeah,
I
yeah,
feel
yeah.
that some education
Yep.
has to fall on the real estate agent.
Yep.
They've got to work in, there's a lot of, there's a lot of faults that begin at the first stage.
Yep. We can, I'm happy to speak to the Real Estate Institute and see if we can influence on that. What I would say from a practitioner's perspective is, if something does go wrong, when they look at the facts of the case, they'll say, what was the earliest opportunity you had to protect your client's interest? I assume that's a question they'd ask. Now, if you've got all that other information, but the contract landed a week before settlement, if you put something on, which I would suggest is prudent practice, when you were first notified, I'm not sure that would have to have some weight. The fact that you got it a week before or 2 weeks before, I would just say, if I was running my own, that's what I'd say. What was the earliest opportunity I had? I did everything I possibly can. As soon as I was aware that I had this level of information, it's prudent practice, I took this step. But I think there's two parts. That's one part. The other part is if we need to speak to the Real Estate Institute about the benefits of priority notices to the consumer. Let's say it's about a consumer protection as well as a practitioner's role. I'm happy to do that.
And also, don't you feel also that because they're the big starting point, that they should also verify their vendor? I'm not saying that we're not to do it. Yes, we can still do it, but a lot of, if we're trying to prevent fraud,
Yep.
how many times it's the agent that has listed a property that doesn't belong to that person? They haven't even checked a title.
Yep.
I mean, these days they're getting the conveyancer to do everything. So they've already sold a property and no searches have been done.
Yep.
That's where the problem is.
Mm.
And no one
you know, we have to, as a group, we have to demand that where the cycle begins,
Yep.
it has to be done properly. I mean,
Yeah,
I've got an instance where they're signing a contract. They haven't even got any searches, not even a title.
Have these,
So why is the onus then, you know, if the agents don't want that responsibility, they may as well not even do, I don't know, contracts or anything.
have these concerns been raised with the Commissioner? I don't have any oversight of real estate agents, as you'd be aware. So, you know, so the Commissioner, he regulates, if you like, licensed real estate agents, and I would suggest if you've got concerns about certain aspects, you may be well positioned to write to him. But I do accept your view.
Sorry, one more thing about prognosis is that I've been told by certain banks that they don't want us to lodge them.
Yes.
That's interesting, because I had a workshop a little while ago, a few weeks, well, probably a month ago, with the major FIs, and I'm aware that one bank has taken a view that they don't see the benefit in them. So I've agreed I'll go and sit down with that bank and explain what I have today. I'm also aware that some of the bigger FIs are going to come out with a policy position that is going to articulate they want to see one on there. So there's a different view held by banks, but I did have the first meeting, let's say about a month ago, with the banks to overcome some of these barriers, and the thing that came up was there's differing policy positions that are about to enter the market, and also the disclosure of the mortgagee was a real challenge, so I'll tackle those as well. Where are we heading? This is really reconfirming what I said in our first information session. Early on, we talked about the alignment of paper and electronic, so therefore there'll be no policy and legislative difference between what you do, whether you choose to lodge through the paper channel or the electronic lodgement channel, and there's a number of good reasons for that. Obviously, one set of policies, one set of requirements. It's easier and more efficient and more effective for you to comply with those. It allows for smooth transitions between the two different channels. If you start a transaction in one channel and for some reason you have to revert to the other channel, if there's different laws and different policies, you then have to go back to your client and explain all of that when you need them to do something else. And obviously that avoids essentially the complexities of the things you need to do to comply. The remaining reforms, which are the subject of the paper, are really the removal of the dupe title. Everyone knows I'd love to get rid of the dupe title. Client authorisations, certifications and executions, and mortgage reforms. So they're really the substance of the paper that's recently been published.
So Brenda, what does the client get as evidence?
Well, what would you like to give them as evidence?
Well,
They get satisfaction to know that the original and it's guaranteed by the government, and there's plenty of things that come out of our system which can be provided to them. They could be given a register search. We will probably introduce another product that won't be called a register search, but it will look and smell like one, and it will give them something that discloses them as the registered proprietor.
That'll be additional costs that we'll have to pay, the client will have to pay.
Unknown. Look, I don't think so, but that's my personal view. I would have thought it's just a value-added something that comes back. You know, a bit like, you know, how people that deal with non-fee simple dealings, you know, the confirmation of registrations, that sort of concept. I'm not saying it will look like that, but that sort of is where I'm thinking. So there'll be something that comes back, it'll just have no legal consequence. But it'll be something that you probably can pass to your client, if they're the purchaser, to say, here's satisfaction of what I've done for you. So the removal of the dupe title is the first of the reforms. Obviously, if we can get the priority notices working and everything else, it is my intention to abolish it. I'd love to be able to be in a position to abolish it as of electronic conveyancing. So as of the second quarter next year, the dupe titles have no further role to play. That's the intention.
It was talked about at one stage that the dupe title would need to be produced for the next dealing in the series, and then after that, no more. Is that still the requirement?
Not my proposed position.
Oh.
No, not interested. I don't see there's a great deal of benefit in imposing that administrative overhead. I think if we're going to decide holus bolus that I'm comfortable in removing the duplicate title subject to all of those safeguards, I'm not sure the additional value of applying the administrative overhead to have them produced and, you know, to check them and all that. It really is a fundamental decision. Can we allow conveyancing to work with or without a dupe title? If the answer is without, make it as easy as possible to transition to that state. If the answer is with, how can we make that work in the environment that we're trying to move towards? They're really the two fundamental questions. I've landed obviously on, I don't believe we need them, maturity of priority notices and the other reforms. Morning. No overheads. From a certain date, done and dusted. Do what you like with them, deface them, throw them away, keep them as mementos. And there'll be an education campaign, I acknowledge that, and an awareness campaign that will have to go with that, because there are a lot of dupe titles and, you know, those sort of things.
So
But
the day before we'll have to do an SC if we can't find a title.
No.
The day after it won't matter.
you would like to think that if the legislation that's required to allow this to happen would be passed sometime well before electronic conveyancing, and so we'll have a clear line of sight about when it's going to be assented to. And so you as practitioners will know this has gone through Parliament, it's been passed, both houses, it'll be assented to on, let's just say, the 1st of May, that's the day electronic conveyancing is going in. Dupe titles from the 1st of May have no relevance. So if someone comes into you and says, I've lost my dupe title, you know from the 1st of May they're not going to be around, then it's a conversation you have about whether.
So try to postpone their settlement until...
That's a decision, and it depends on what they want to do. That's just the, yeah. The one thing that's not in the paper that I just want to bring to people's attention, if they could consider it and if they wish to put a response in, is that in the legislation currently, obviously we have an optional around mortgages being lodged in duplicate and encumbrances in duplicate. You know, you can lodge them either single or in duplicate. I'd love to know whether we can take that provision away and just allow for them to be lodged singularly, mortgages and encumbrances. Similarly with leases, we know we have leases, lessees copies of leases, they're in duplicate. Is that still needed? Now, I don't have a view, and obviously because it never made it to the paper, but through our drafting instructions, the question was asked to me, oh, what about these three, you know, dealings that we traditionally have in duplicate? Do we want to firm them up to say, no, they're all single copy because we're going to move to electronic conveyancing, and leases at some point will be included, whilst they won't be from day one. Is it something we want to tackle now, or do we think, look, just leave it as a status quo, and when we go to bring them in, we'll tackle it? That's a question for you to consider, as I don't really have a strong view either or. It's really about the functioning market. I'm aware, you know, lessees probably would like to have their duplicate lease if we use that, but the same challenge that exists in that regard would be the same challenge for dupe titles. So to me, the conversation is very similar, but it's just food for thought. Again, the reasons around the dupes, you know, they're not compatible with a move to an electronic system, or there'll be costs if we want to keep them in the use of an electronic system. So if we can remove them, obviously it reduces costs of storage, retention, retrieval, and obviously with SCs and things like that, it also makes it cheaper if we move down that path. And there's other reforms, as again I've touched on, that I believe we need maturity of to put the adequate safeguards in to allow us to abolish dupe titles. As people be aware, currently the dupe title is produced from the first mortgagee or incumbency if they're on the title to enable subsequent dealings. It's my view that these first mortgagees are afforded protection over any subsequent interest by the workings of the system. You know, they're a registered first interest, etc. So I'm proposing that if we remove, and us can remove the dupe titles, that we don't need to introduce consents. So at the moment there's this quasi-consent, because if I'm a registered first mortgagee and someone wants to do something, an application to register death or whatever, I produce the duplicate, so there's an implied consent because I've handed over my duplicate, and so you're aware. Right? What I'm proposing is, because the mortgage is registered, they have first registered charge. There's no need to get anything if someone wants to register an application to register, you know, some other, not something that changes the proprietorship obviously, but something that, you know, does not affect their particular registered charge. Now that other jurisdictions, some people yesterday mentioned, oh, the financial institutions won't like that. They like giving consents and doing things. All my response was to that is, in two other jurisdictions, they've strongly considered, well, one has introduced consents, the notion of consents, and they're trying to deal with it in an electronic way. And the ABA, the Australian Bankers Association, representing the financial institutions, have strongly lobbied to have it removed. Unnecessary overhead that they don't believe they require. So I'm just using that as a guide to put that out there. Again, it's only advocating a position. If the ABA or that come back and say, no, we think there is a role for consents, and we'll need to consider that in how we do that. But at the moment, the evidence is the banks are reasonably comfortable with this notion that they have first registered charge, so therefore, you know, their interest is secured.
So
So
they
even-
do, oh, sorry.
I was going to say, even if there's a planned division,
Different. Division documents I've sort of pushed aside. You'll notice through the paper, and when we get to client authorisations, division documents, I use that term broadly, they're a different kettle of fish that require a whole another level of thinking. I'm not sure it's that difficult to overcome, but it requires an acute focus, and at the moment we're focusing on really electronic conveyancing, and then we'll move to those division type documents. But so consents for a division document is a different thing. It's more in the consents where once upon a time they'd hand over the dupe title. Where they would do that, we're not intending that to be substituted with anything.
So just continue with that. What about leases? Leases are required to have consent to a bank if there is a mortgagee.
We're still going to, well, that will be covered.
That will be covered
Yep.
in this.
Because that will still need to function.
Yes.
Yep.
Brenton, just with the subsequent mortgages, I think it would certainly help us if the title didn't have to be produced. From the bank's point of view, priority of monies,
Yep.
has that been discussed with them around how that works?
My understanding, and this is my understanding, from other jurisdictions is, for instance, Queensland, they don't have consents. So what they tell me, and the banks that work in the Queensland state, that's handled outside of the settlement process. So that's a communication between the two banks, notwithstanding the duplicate. So that it still happens, but it's communication between bank to bank rather than everything else. So that's, I think, on the ground what happens in Queensland.
Yeah, I think that still happens here in terms of needs of priority and things like that. So that process will still take some time.
Yeah, okay.
But from our point of view, I guess we don't need to follow.
Okay.
It doesn't involve you because it's a breach
No.
of the first mortgage insinuated logic.
There's covenants that bind the mortgagor anyway. Yeah, there's covenants. Like those disclosure things as well. Client authorisations. So we've touched on these briefly, and so what a client authorisation is doing is the client will sign a formal authorisation allowing you to sign and certify on their behalf. Again, I'm proposing that this is both in paper and electronic. So at the simplest form, if we... Oh, what happened then? So in the simplest form, if we take a transfer, for instance, where the transferor or transferee, they both personally sign, their signatures are witnessed, no longer the case. The transfer will be signed by the practitioner acting for the transferor, and also the practitioner acting for the transferee, and that's it. Well, depends, they may be represented by different, but two signatures
do you think
in most
that's
cases.
possibly going to cause more fraud?
In what regard?
Well, just speaks for itself, I think. So
It depends
you're-
what regard you're talking about.
I mean, anything can be lodged then without the client seeing what's been transferred.
Yes.
I mean, I'm not saying...
We talk about later on in the paper an alert service, which we're seeking your views on.
Even with practitioners, you know, there have been, you know, ones that have been tempted in the past.
Mhm.
Could this possibly be a temptation as well? I think this possibly could open up a can of worms for fraud.
My response to that would be if practitioners are that way inclined, the opportunities are there today. I don't see this adding any more or less merit to a practitioner wanting to do something that's fraudulent.
But it's temptation. I mean, you know, we haven't had much fraud here in the system that we've got. Now we're going to where, you know, we're going to be signing
Yep.
and we're
Yep.
signing for the client and we're certifying for the client.
One signature, same thing, yep.
Uh,
From a fraudulent perspective, if you're a practitioner and you want to be fraudulent, you just sign the document and you pretend you're that person and you witness it yourself. There's no greater or less.
I'm saying someone else's name on that document instead of the person who's meant to be on there. That's what I'm saying.
So Brendan, it's called forgery today.
Yeah,
Why?
I'm not sure I see I'm not sure I see any greater or less occurrence or opportunity. I think if it's the way someone is inclined to be.
But then you're really taking everything away from a person who's outlaying, thousands of dollars in a purchase or whatever. You're taking everything away from that person. I mean, unless the public is going to be well and really truly educated that they're not going to get a duplicate title.
Yes.
They're not going to sign the documents. I mean,
Yes.
we're going to have a hell of a time trying to convey that to clients. And I think the onus is put all on us. I mean, they're not even going to sign a transfer.
Yeah. My response is the onus has always been on you. And it always has. And I've had this conversation numerous times with many people. Once you put that certificate on the back of the document, it is your responsibility to ensure. And so all this is doing is, one, it's when we get the certification, is further codifying what you should do, and two, aligning the reforms to a national system.
Clients have to know. They have
Absolutely.
to be aware of all of this.
Absolutely.
They're going to be hit. When are they going to be told all this?
When are they going to be told all this?
The identity really
Oh.
wasn't publicised at all.
I would
And
suggest.
I think this is a very tender, you get an old lady or anybody, even a young person, they're giving you $500,000 or $1 million, and they haven't even signed, they'll sign an authority, but they're not even signing a legal document, you're saying.
The client authorisation is the legal document that legally authorises you to sign on their behalf. And what it comes down to is the conversations the practitioner must have with their client.
We have to hold a document.
You would be explaining to your client, surely, if you're acting on your client's behalf and it's $1 million property or a $500,000 property or anything else, surely there would be a conversation, this is the role I play on your behalf and these are the checks and balances I bring to the service I provide you. Now, this is an extension and a formalisation of that service. Does it change those conversations? I don't think so. Because you would like to think that when you've got a transfer and it's a meaningful, you have that conversation with your client and say, look, I'm going to get you.
They're not going to be signing anything.
They're signing a client authorisation.
We're going on a verbal.
Yeah.
So Brendan,
This,
to a large extent, that client authorisation's gone through 9 revisions. It is the document. Generally, people would sign a transfer and an authority to act at the same time. If they sign the client authorisation, it is a formal legal document binding you. It's your retainer.
Yep.
And whether they sign a transfer or not, quite frankly, is
So
irrelevant.
is that going to, that client authorisation form, is that going to be something that you'll publish?
it's published. Well, sorry, there's drafts published. We're revising it at a national level. So the client authorisation form is a regulated instrument as part of the model participation rules.
No, well then
Okay.
I take that on board then.
Thank you.
Brendan, when do you get this client authorisation form signed? Is my question. I mean, say you get the client to authorise you to do it, and they drop off the perch before settlement.
It's all covered in the model participation rules and the functioning of law. It's the same as if they execute, I can't remember the nuances of it. If the client authorisation is signed, the contract's entered into, there's still the equitable interest that's passed with the contract being entered into.
But should not the executors be stepping in then and taking
It
over?
works at law. No.
Because if one of my clients instructed me to act for them and then they
But
drop off the perch, I'd have to go through that whole other business before I got the transfer signed.
The clients would have signed the contract, though. The contract still exists. So the contract's the binding and creates the equitable interest, and then the transfer creates gets the legal estate. So the
But in the
client,
meantime, you've got to have executors and everyone appointed.
But you have to
Get a
deal with
current-
that
You have to deal with that now.
You've got
There's
to
no
put
different.
Paper there. You've either got an AT or a TA in
What?
between. It's no different.
Yeah, it's no
What
different.
I'm saying is, what's to stop someone from just signing and lodging on the basis that, oh, well, no one's going to know he's dropped off the perch before he signed all this?
well, there's penalties,
I know, it's fraud, but it
and
can
there's
happen.
yeah. I'd hate to think what
Whereas it's very difficult for it to happen now.
is it? Okay. I'm not sure I probably agree with that position, but I take your point. The client authorisation is closely linked to the VOI. So you verify your identity of your client. You must then obviously be satisfied that they are entitled to, they are attached to that piece of land for which you are acting for them on. In the latest model participation rules, which are national instruments, it was explicitly linked. So in the last draft that went out, it said when the VOI is undertaken, the client authorisation must be signed at the same time for you to get safe harbour. We received feedback, again referring we as a national, that that wasn't appropriate. The market preferred there to be reasonable steps. So what we're saying now is you do the VOI, and then when you do your client authorisation, you need to be reasonably satisfied that the person that's been identified is the person that is entering into the client authorisation. So how you build that link is really a discussion point between you and your client and the evidence you have in front of you.
What about absentee vendors?
In what regard?
With verification and
When you mean absentee vendors, what do you mean by absentee? Overseas? You need, well, at the moment, the NPR says they go to a consular office. That is about to be removed though, because you can't obtain safe harbour in that regard. And so there's some practical limitations on the rules. And so the next rules that would, well, they're still being considered, but the next rules that come out will probably remove any reference to overseas verification and will say you've got to take reasonable steps. And then there's guidance notes that will simultaneously be published that will codify or give you a clear understanding of what may be constituted reasonable steps, but it won't be in the model participation rules. And that'll be published by the end of this month. Fingers crossed. So the client authorisations, effectively, it's about the removal of the punter's signatures from the documents. It removes witnessing, and as I mentioned, it is really comes down to the practitioners signing the dealing. And again, this is where we are aligning with electronic conveyancing. In the electronic conveyancing world, to be a subscriber, a user of PEXA, the electronic conveyancing system, you need to have, there's certain criteria, legal practitioner, conveyancer, ADI, you have to have insurance, etc. And so to work in that domain, it's impossible for the punter to sign. So client authorisations are absolutely essential for electronic conveyancing, and this comes back to that alignment principle that we've been moving forward on. So it's aligning the client authorisation and its use across both channels. And I'm happy to hear any of your feedback or your submissions about that. My concern is if we don't align, there's significant cost and complexity and inconvenience to the consumer, because you may not know what channel you're going to use. And so if you start out using the electronic channel and you have to sign on their behalf because that's the way it's structured, so you have to have a client authorisation, you have to have that conversation with them, and then all of a sudden it falls out to paper and the client authorisation is no use, and you all of a sudden have to get them back in and get them to sign a transfer and have it witnessed, it just gets very, very messy from my regard. But again, it doesn't, from my position, it doesn't really affect the operations of the LTA. It's about an efficient and effective market, and as I said, I'm happy to hear any views. Notwithstanding, client authorisations absolutely will be happening in the electronic space.
Sorry. In regards to client authorisations, if I'm bank lodging a mortgage,
No.
I wouldn't need one, would I?
No. There's some of that coming up. So there's some exceptions we're proposing to the use of client authorisations. Part 7A, anyone that's ever done old system land has some declaration parts to it. Documents that require personal declarations currently, we've sort of said they're exempted because it is a personal declaration. And more broadly, we've said 19AB in the paper, but more broadly it's division documents. Again, I don't think it's insurmountable about having client authorisations apply to them. It's just it requires a real focus, and at the moment we're concentrating on the whole of the land transactions. So that's what we're proposing at this stage. One of the things you will note, sorry?
Brendan, just the ones on the personal declaration, things like application note, marriage or change of name,
Still there.
Are they included in that? Because if we're going out and doing the verification of ID and checking all of that, it seems that it's pretty straightforward.
They are included in that, right?
Yeah.
But it's only until we go through and align nationally. Because nationally, it's fair to say there's some thought about removing those documents effectively in the majority of cases where you can tie it up in the transfer order and then it will flow through to the title, if you like, if they're remaining on, where at the moment we say you must lodge a change of name. So there's some practices that are still being negotiated on. Once we land on those, it'll impact that for certain. The other thing you'll note that we haven't excluded is leases. Now, people have spoken to me in passing that leases may not fit under client authorisations because of the covenants that are contained within, and so they may not be suitable to the use of a client authorisation. And so I just turn your mind to that for consideration about whether leases can be executed under client authorisations or not, because of their personal covenant type nature. But you know, that's again, it's not really something for me. I'm just putting it out there that we didn't include it at this stage, but it might be something you'd want to consider. We've said they're optional for priority notices and caveats, so you don't need one. If you've got one, it won't be a barrier, and it's not a problem at all. But you don't actually need them to lodge those type of documents, given they're sort of priority type documents that you can get in as soon as you receive instructions and/or some other notification.
Excuse me, Brendan. Withdrawal of caveats, we can put caveats on for clients, but withdrawal always has to be signed by the clients. What's going to happen?
They're not an exemption at this stage. They're not an exception at this stage. I've touched on this. Really, this fits under the use of client authorisations, and it's really just to bring to your attention execution clauses. They will be removed from all of our panel forms, and obviously there'll be 2 signing blocks, one for the transferor and one for transferee representative. But it's just to highlight the fact that there is significant reform around the way documents are completed, and we will make those changes to our forms online or our published panel forms anyway. Certifications are going to be codified. I've had a number of people over my time in the role talk to me about what does it really mean. I think it comes back to our discussion around, you know, your obligations, where I've always had the view that once you give me a certificate, you have an obligation, and it's a fairly strong obligation. You know, you can't say, oh, the document's witnessed, therefore it's their problem. That doesn't reside with me at all. And I've had those conversations over many, many years around what does it actually mean when I certify something correct under the Real Property Act? You know, I put my signature certified correct, but you know, what does it mean? What we're trying to do is codify explicitly your responsibilities when you sign the document. And so it's an expansion, if you like, or codification on what it is that you are certifying to me or the government what you have actually done. And they'll be required on behalf of all transacting parties, so transfer or transferee, if they're separately represented, 2 signatures. If lessors, lessees come in under client authorisations, lessor, lessees representatives will have to sign as well. So it just depends where we land on the leases. So it's really where there's a party that normally executes, their representative will certify on their behalf. That's in simple terms. So what are the things you're going to put your signature to? And these are consistent as much as they can be from a terminology point of view with electronic and paper. So you've taken reasonable steps to do the VOI, you hold a properly completed client authorisation, you've retained the evidence, and you've taken reasonable steps to ensure that it's correct. Identified your client, attached them to the land and have the authority to sign, kept the necessary documentation, and there's nothing else that you're aware of that should be considered in this transaction. And they're consistent. Well, nearly nationally. They're consistent as much as they can be around terminology. So we still need to cater for self-represented parties. So if you like, these are written in the first person. So if you're a self-represented party, other than a mortgagee, you know, I'm the person identified, you know, you've obtained and prescribed legal authority, etc., etc. So they're just there's examples of first party.
How do self-represented parties manage settlements if everything has to go electronically? They can't play in electronic conveyancing. So what do they do?
Face to face. Yeah.
It still will be.
Oh yeah. There's no idea at this stage to mandate use of electronic conveyancing. Not in South Australia. I can say other jurisdictions are already considering mandating. So it's moving pretty quick. But my view is not in the short term. There's been some work undertaken on mortgage reforms at a national level. So it's led by some of the jurisdictions and also the Australian Bankers Association. And so there'll be two ways that mortgages could be executed at the time we go live with electronic conveyancing. So they can be like they are today, so signed by the mortgagee physically, signed by the mortgagor, and certified by the mortgagee. Or the mortgagor no longer needs to certify the dealing or the instrument that's lodged with me. The mortgagor can lodge the dealing and give me certain certifications. So it's only signed by the mortgagee and or their representative. And so that's where we're going. Effectively, the national mortgage solution in the electronic space is the mortgagee gives me the certificate and gives me certain undertakings, and they hold whatever valid mortgage they have on the same terms back in their office. That's where the national mortgage is going to. We're not there yet around being able to implement it simultaneously with electronic conveyancing, so that's where we've gone the old either or. But it's fair to say dot point 2 is the long-term goal. So there's some certificates they must give me. So the representative of the mortgagee's taken reasonable steps to verify the mortgagor, and they hold a mortgage granted on the same terms. So they have a mortgage that's been signed and etc. on the same terms as the instrument they've provided through the exchange or over the counter if we do it in paper.
And is that why we don't need your client?
Yeah. Yeah. Yeah.
Question. In regards to the mortgage, would that certification need to be done by a conveyancer or a solicitor acting on behalf of the bank, or can it be?
There's changes. There's changes.
There's changes. Yep.
Yep. So it can be done with an employer. Yep. Yep. What we're also doing to keep the mortgagees honest is to introduce some statutory requirements around their reasonable steps and that the mortgagor is legally entitled. And so these provisions already exist in other jurisdictions. And it's where the registrar has the power to cancel the mortgage if they don't comply with those obligations and there's fraud. So that already happens in New South Wales and Queensland, and Victoria are about to introduce it. And so whilst the mortgagee has some ability to certify and lodge a mortgage, if there is fraud, I have the ability to cancel it. We've talked about consumer awareness and consumer alerts and how would people know, and it is a concern. So one of the things that was brought up when the first bill went through Parliament was an alert service. And so the attorney was on the record of saying that himself and I would work or investigate the ability to introduce an alert service. So this is out there for your consideration around the value of a particular alert service. And simply it's about someone subscribes to a product or a system. If there's a thing that happens, i.e. a priority notice is lodged, a property interest report is ordered, a mortgage is actually lodged for registration or a dealing's lodged, there's an alert provided to the subscriber of that service by SMS or email. Now that's very basic, but that's what we're doing. We have some good lead indicators obviously in South, the property interest report's a good lead indicator, and also if we can get priority notices, thank you, they will be good lead indicators to alert the subscriber, landowner, that something's about to happen on their property, and if they want to take some sort of action, they can make that decision. And so it builds that circle if we possibly can to keep people fully informed.
Just on that, will that be something that you're proposing that clients will have to pay for that service as well?
Yet to be determined. It's yet to be determined how we would do that and how we would administer it, because if we administer it through the practitioners, we have the same issue that you brought up, that if the practitioner wants to be fraudulent, it's not going to add any value. Because if the practitioner wants to do something that's a bit untoward, they'll put the alert service back to their untoward email address or SMS, and the circle just never is closed. So that level of detail hasn't been thought about as yet. My personal view is I think it has merit. I think the devil's in the detail though, about how you would administer that and the cost of administering it. But I think where we are going, not necessarily maybe in 12 months, but in 10 years' time, and we are fully electronic and we're in a fully trusted system, and we're dealing with assets worth a lot of money, I think there probably has to be something that flows back out to the landowner. So it's just for consideration. You know, the attorney didn't commit we would do it. It's more an investigation and the worth to the consumers and obviously the practitioners that would probably have some role in the administration. That the devil's definitely in the detail in that one.
Yeah, just the thing is concerning purchases coming forward. You've got stamp duty, LTO fees, then they have to pay for tax, and then there's this other thing. Everything just seems to be increasing for them. I know it's something that happens regularly, but there needs to be a lot of consideration because by the time they get to our office, they're fuming at us because they think we're charging all these fees, yet the government mandated.
Yep.
No, the registration fee is going to drop.
Yeah.
It is?
I wouldn't have thought so.
To zero.
I was. Well, I'm glad you opened that door, Jeffrey.
Between you
I saw a publication that was published by PEXA just recently about the benefits to all land registries around the country, and it was something like $5 million at a national level. So, if you work out South Australia's percentage of 5 million, given we're 6% of the market, it doesn't translate to significant dollars. And then if you divide that by the 200,000 transactions we have lodged a year, you're talking $5.
That was a self-serving piece of crap.
Anyway, it was a well-published, well-researched paper, but I appreciate your views.
The banks and the registries are the big savers, mate. If they don't foot some of the bill, we won't be paying. That's simple. Can I just ask a question about that certification by ADIs, please? So, just going back a couple.
This one?
Yeah, so the NPR's got ADIs is listed as subscriber, so effectively that certification by an employee of the ADI.
Yes.
Limited to the employee, or is that
Yes.
X or one of the others?
Sorry?
Is it or can it be extended to the party that settles for them?
No.
Global X or
No.
anything else? So it's an
Not
employee
my
of
view.
the ADI,
Yep.
and that includes the certified correct?
Yes. Yes.
So we're not going back to powers of attorney
No.
for certifying OE register?
No. 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 No.
Is there a view that the registration fees may differ between the electronic and paper channels?
Not at this stage. It will be something, it's fair to say, I expect it'll be a discussion that would need to be had in the next 6 months with Treasury officials. So the whole pricing regime, I know I was a little bit flippant. Sorry?
It's actually cheaper in Victoria because they offer a lesser fee. For
Yeah, but you're talking minimal.
to take it up.
Yeah, it will definitely need to be a discussion, and of course, yeah, and it'll be dependent on the magnitude of what that discount, if it is approved, what it is, because it needs to be probably meaningful. Because as I say, if you start in a certain channel, then you fall out in the other one, and you've got to redisperse and it's got to be. So those conversations will have to be had. As Jeff spoke, Victoria have a marginally cheaper rate through the electronic channel. It is very much marginally. I think it offsets the service supply that the Lands Titles Office provides PEXA. So I think it's in the vicinity of $10. Don't quote me on that, but I think it's roughly $10. So, but as people would be aware, those questions would be for the Treasury officials to consider and government more broadly. Next steps, the paper is available and circulated today. I encourage everyone to put in a submission if you have some views. We'd love to hear from them. Yesterday someone spoke at the forum and said, look, a lot of it's, and this is me paraphrasing, a lot of it's a national initiative, and therefore any feedback is limited in how far I can go to really consider it. And so there was a thought that, so therefore is the feedback, is it really warranted us to go that far in regards to this consultation, given a lot of it aligns nationally? And it was a fair question. What I responded to that was, the reforms are fairly set in regards to electronic conveyancing. The breadth and the application of those reforms to South Australia is what we're consulting on effectively. Can we move away from client authorisations? The answer is no in PEXA. Do we need to absolutely align electronic and paper? Probably not. If you tell me you don't want to, we would need to consider that. Do we need client authorisations to apply to all documents? Probably not. And so it's really the breadth of these reforms and the application of these reforms and how they impact your business that we really want your input into. And if there is some around the detail, we'll take that back to national, but it's a bit harder to shift in that regard. But the application of these reforms and the breadth of these reforms and the impact of these reforms onto South Australia is where we would hear your views. Absolutely. And you do have direct input into that. These consultations close on the 24th of July. So if we can get them in by that time, it would be appreciative. We're on a tight time frame with Parliamentary Council. I believe the draft bill will need to be finalised well before Christmas, and as stated there will be consultation on the draft bill. So I'm hoping this side of Christmas, as I smile to my sisters. It needs to be this side of Christmas really to get through the political system early next year with the sitting days and just the process that you need to follow. So consultation closes, be well considered, draft of Parliamentary Council, draft bill out for consultation. And then early next year, it'll be focused on education, awareness and PEXA. They'll be here early next year. They've changed their model in regards to implementing PEXA, not from a training and education point of view, but they've learnt from some of the other jurisdictions. So now their approach is, once it's up and running, they attach, if you like, a customer service officer in PEXA that works with a group of around 20 direct clients. So they have a direct relationship with their clients and they go out with the clients and work with them to drive uptake and develop understanding and comfort with the system. So I was pleased to hear that strategy evolving in some other jurisdictions. Hopefully it's well advanced, and then when we introduce it into South Australia, we can just dovetail on that model and they can apply the lessons and the success of that model into our market.
Did you say that was second quarter? The plan at this stage next year?
Yeah. They've given me a date, but I'm reluctant to. It is the second quarter, early the second quarter, but I think we might need another month. There's a fair bit of testing that needs, so at the moment it's April, but I think it will probably be more May.
Brenton, if you have a party like a self-represented party,
Yeah.
or they have to lodge face to face, and then you've got someone doing it electronic, will that work?
No. No.
So then what about if one party won't give in?
Goes paper.
And can I, sorry, just ask, I apologise if, I should know. If you're acting like, say, for a purchaser, you certify your own document, it's...
Your own account, yes, go on.
You're on your own account, and then the vendor's representative verifies his document.
Mm-hmm.
So, do we see each other's documents in the transaction, like when it's electronic?
In the workspace?
Yeah. Oh, we will.
Yeah, there's certain privacy controls over certain aspects of it. So if you like personalised information, i.e. PEXA has a attributed date of birth. Now, I'm not sure the purchaser's representative sees the date of birth of the vendor, but you'll see the majority. Yeah. So what they've done, effectively, as it works, is it's all one style sheet, if you like, but you have access to your information and you certify your counterpart to the transfer. The vendor's purchase representative searches there, and it's sort of.
So
but you do.
Still cross-check each other.
Absolutely. You have to be able to put your digital signature to say you're okay now to go to settlement. Yeah. Full visibility. Absolutely.
So Ben, just to clarify something on the training, so PEX has actually appointed AIC nationally to be the trainer to our practitioners.
Okay.
And so that was
Good.
yesterday. So effectively the ALCs will take it up, and there's a train-the-trainer process, and then basically ALC will present it to their members for several reasons. One, for consistency mostly, because if it went anywhere else out to sponsors, it will always have a bias towards the sponsors. So in fact, in addition to what you're talking about the PEXA, mind you, 24 people are going to go Australia-wide on it, so there won't be enough. So that's why ALC
Initially,
offer that, and we'll take it up and train our practitioners. And what the Law Society does, who cares?
I'm certain with the presence South Australia has on the national thing that once we're into South Australia, we'll get all the support we need. No doubt at all. And if that means personalised service or increased foot soldiers to make sure the training and the first-hand support's there, we'll lobby fairly strong and hard to make sure you get the support you need.
Well, most people may or may not be aware that Jeffrey Adams stood aside as the CEO, is now the projects officer for the time. He's taken that role on himself in terms of, so that people are as trained to the guilds as possible when it lands, because I'm not sure about it being mandatory, but it's certainly going to be pushed hard.
Yep.
because of the savings that you will make and the banks will make.
Did you have a question? Oh, is that all right? All right, well, thank you. I appreciate you taking time out to come and listen. I encourage anyone to put submissions in, and I'm sure we'll see you again soon. Thank you, everyone.